Welcome to this explainer. Imagine for a second that a nation's constitution is basically its ultimate rulebook. It sets the boundaries, defines the players, and lays out the entire game of governance. But what actually happens when the players decide they just want to change the foundational rules of the game itself? Well, that is exactly the high-stakes constitutional tug-of-war we're exploring today. The fascinating evolution of the basic structure doctrine.
Okay, let's dive right in. So, can a government legally rewrite its entire democratic rulebook? It's a massive question, and it's the central conflict here. On one side, we've got the parliament. They're the rulemakers, representing the will of the people, right? And they're demanding the power to amend the Constitution to drive social and economic change. But on the exact opposite side, you have the Supreme Court. They are the referees, tasked with protecting our core rights. And let me tell you, when these two forces collide, sparks absolutely fly.
Now, to wrap our heads around this 50-year legal roller coaster, we've broken it down into 5 easy chapters: the amendment battlefield, the birth of the basic structure, testing the limits, the 9th scheduled shield, and finally, modern rules and ordinary laws.
This wasn't just some isolated event. What we're looking at is a constantly escalating battle between the Indian Parliament and the Supreme Court. It's a saga punctuated by landmark cases that kicked off in 1967, blew up during the turbulent 70s and 80s, and sent shockwaves right into the 2000s. Let's kick things off with Chapter 1, the Amendment Battlefield, setting the stage.
All right, picture this. The year is 1967. The Goloknath family owns a massive 500 acres of farmland in Punjab. But the government, who is really pushing hard for land redistribution and reform at the time, passes an act limiting individual landholdings to just 30 acres. That's a huge drop. Naturally, the family pushed back, and this sparked a massive constitutional crisis. They argued this strict limit completely violated their fundamental right to property, and they directly challenged the constitutional amendments that shielded these land reform acts from any kind of judicial review.
And the Supreme Court delivered an absolute shockwave. By a razor-thin 6-5 majority in the Goloknath case, the judges essentially looked at Parliament and said, fundamental rights are sacrosanct, you cannot touch them, you cannot limit them, and you definitely can't take them away, not even through a constitutional amendment. They ruled that an amendment is technically a law, and therefore it just cannot violate fundamental rights. As you can imagine, Parliament was completely stunned by this.
So, you gotta ask, is the pen mightier than the Supreme Court? Well, the government certainly thought so. Parliament quickly retaliated by passing the 24th and 25th constitutional amendments in 1971 and 1972. They explicitly granted themselves the power to amend any part of the Constitution, yes, including those sacrosanct fundamental rights, and they severely handicapped the court's ability to even question these changes. They literally rewrote the rules to give themselves ultimate power.
Which brings us right into Chapter 2, the birth of basic structure, and the major turning point in 1973.
This brings us to what is arguably the most monumental chapter in this whole saga, the Keshavananda Bharathi case. It involved a Hindu religious institution chief whose property was being targeted by Kerala's land reforms. Over a grueling 68 days, a massive 13-judge bench wrestled with Parliament's new amendments. Ultimately, in a historic 7-6 majority, they brokered a truly brilliant compromise. They said, okay, yes, Parliament can amend any part of the Constitution, including fundamental rights, but, and this is a massive but, they absolutely cannot alter or destroy its basic structure or essential features.
Now, 6 of the dissenting judges believed Parliament's amending power was plenary, meaning completely unlimited. But the majority, who were heavily influenced by Justice H.R. Khanna's pivotal reasoning, believed in what we call implied limitations. Justice Khanna essentially argued that the very word amendment implies that the old Constitution has to actually survive without losing its core identity. Basically, you can repaint the walls, maybe change the furniture, but you absolutely cannot destroy the foundation of the house.
So what exactly is this basic structure? Put simply, it's the fundamental framework or the underlying identity of the Constitution. Sure, Parliament can tweak the rules of the game, but they absolutely cannot use the amendment process to commit lawful harakiri. They can't, for example, just suddenly replace a democracy with a dictatorship.
Now, to anchor this somewhat abstract concept, the judges laid out some tangible, indispensable democratic principles. We're talking about things like the supremacy of the Constitution, the rule of law, the separation of powers, judicial review, federalism, and secularism. These are the core features that ensure your everyday rights actually mean something. If you destroy any of these, you just don't have the same Constitution anymore.
Moving on to Chapter 3, Testing the Limits. Let's talk about elections and unlimited power.
Justices Khanna and Chandrachud viewed the Constitution not just as a list of isolated rules, but as a deeply interconnected network. Concepts like democracy, equality, and judicial review, they are all inextricably linked. If you pull out just one node, the whole structure could collapse. And this exact network was put to the ultimate political stress test during the Indira Gandhi case in 1975 and again in the Minerva Mills case in 1980.
Let's look at 1975. The Allahabad High Court actually set aside Prime Minister Indira Gandhi's election. In immediate response, Parliament rammed through a constitutional amendment inserting Article 329A. Let's de-jargonize this for a second. It was basically an attempt to create a massive, special constitutional favor. It placed any disputes concerning the election of the Prime Minister completely beyond the reach of ordinary courts. It was literally a rule made retrospectively for one specific person regarding one specific election.
Well, the Supreme Court stepped in and struck that specific article right down. As Justice Matthews so beautifully articulated, adjudication by an independent forum in election matters is the essence of democracy. The court strongly reinforced that free and fair elections, along with equality before the law, are the absolute bedrock of the basic structure. Because think about it, if contests for the highest office in the land are selectively removed from the rule of law, everyday democracy pretty much ceases to exist.
But the tension definitely didn't stop there. Cut to the 1980 Minerva Mills case, where Parliament tried once again, this time passing Section 55 of the 42nd Amendment. This section explicitly declared there shall be no limitation whatsoever on Parliament's amending power. None. The Supreme Court's response to this was an absolute masterclass in legal logic. They struck it down by pointing out a massive irony. Parliament only has a limited amending power, which was given to it by the Constitution itself. You simply cannot use a limited power to grant yourself unlimited power. And just like that, judicial review was saved.
Let's jump into Chapter 4, the 9th Schedule Shield. Was this a constitutional hiding place?
I want you to imagine the Ninth Schedule as this giant, impenetrable constitutional safe. Historically, if Parliament took a law and locked it inside this safe, it was meant to be completely immune from judicial review regarding fundamental rights. The IR Kohilo case in 2007 asked a highly critical question. In a post-case of Ananda Bharti world, can Parliament just hide highly controversial laws inside this safe to entirely bypass the basic structure doctrine? Well, a massive 9-judge bench finally managed to crack that safe wide open. They unanimously ruled that you absolutely cannot do indirectly what you are expressly forbidden to do directly. Even if a law is physically placed into the Ninth Schedule via a constitutional amendment, if that specific law damages core constitutional principles, it can still be struck down. So the shield? It turns out it's not actually absolute against the basic structure.
And that brings us to our final section, Chapter 5, Modern Rules and Ordinary Laws, the 2024 Standard.
So, you might be wondering, how does this overarching massive doctrine apply to everyday legislation that's happening right now? Well, there's a critical, highly nuanced difference established in recent rulings, like the Madras Bar Association case and specifically the 2024 Anjuman Kadari case. A constitutional amendment can be struck down for violating the basic structure doctrine. However, an ordinary statute, meaning just a regular, everyday law passed by the legislature, cannot be challenged purely on abstract basic structure grounds.
The 2024 Anjuman Kadari case really clarified the test for these ordinary laws. If judges want to strike down a regular law, they can't just throw around broad, undefined concepts like democracy or secularism in the abstract, because honestly, that would just create way too much uncertainty in our legal system. Instead, they have to prove the legislature actually lacked the competence to pass it in the first place, or they must point to a specific express constitutional provision that's being violated, like Part 3 fundamental rights. Basically, the rule breaking has to be explicitly traced back to the text.